Arun, and I said I'll focus only on prohibition, and Arun will then take over on the writs. So I'll quickly come to prohibition because I'll try to finish as fast as possible. The writ of prohibition, as I found it, I did some research, and I had a lot of slides, but I've just cut short the whole thing. Shall I just keep you ready with the slides if you can?
Yes, sir.
Yeah. So the writ of prohibition is basically what it means. It is to prohibit an inferior court or inferior tribunal from exercising jurisdiction which it does not have. As the Supreme Court said, it is to prevent usurping jurisdiction or lack of jurisdiction. I've just given on the slide here the meaning of the word in corpus juris secundum. There's a similar definition in Black's Law Dictionary. And historical background, because as Justice Sahi mentioned, now we don't have to much go into history. We have developed our own jurisprudence. But academically, it started with the conflict between the ecclesiastical courts and the king's tribunal. In fact, even the contempt jurisdiction was the offshoot of the conflict between the ecclesiastical courts and the temporal courts. So this was a conflict between the ecclesiastical courts and the king's tribunal. And then ultimately the king's tribunal wanted to put the ecclesiastical courts in their place and said that, look, as a ecclesiastical court, you confine yourself to religious matters. You're prohibited from getting matters which are the basic matters in the realm of the king's tribunals, the king's court. So that was what the next slide, Sharath.
Yes.
Now, I mentioned the modern writ of prohibition. It is to prevent a body from acting unlawfully. And the second point is important. We started with judicial acts. And like certiorari after A.K. Kraipak, you have gone beyond judicial acts and now gone to administrative acts also. Incidentally, I'll stop here for a minute. And if you see both Article 32 and 226, prohibition is the only word not mentioned in italics. You will find that habeas corpus, quo warranto, certiorari, mandamus, all are mentioned in italics. Only prohibition is mentioned in simple language because it's not a Latin word. It's used as an English word. I found it rather unusual that only prohibition is mentioned in plain English. And it's now gone to administrative acts also. It is to prevent a public body from exceeding or abusing its statutory powers. Now, just go to the next slide. Yeah. The certiorari and prohibition are basically at two stages. In simple terms, certiorari is after the event, after the order is passed, you can quash it on grounds like error of law and so on. And prohibition is to stop the person. It's more preventive rather than curative. One point I want to mention is these are two important judgments on prohibition. I just made the slides for the younger audience. That Govinda Menon's case, which is very important. And what is important there is Subbarao, Justice Subbarao says, it's not only in the case where there is a absence of jurisdiction, excess of jurisdiction, but even where there is a departure from rules of natural justice. So this is a very unique point. Even if you feel that the concerned authority is departing from the principle of natural justice, you can issue a writ of certiorari. Right? Then Isha Bibi says that where there is total absence of jurisdiction, you can issue a certiorari. Now, in practical points, I had the occasion. I always feel that prohibition is a writ which many lawyers forget, and it's a writ which you can use for several matters. And I had the occasion of using prohibition again and again and again, particularly in tax matters. And this came because of list 1 and list 2 of our constitution. As all of you know, the union list has certain taxes, income tax, central excise, custom duty, and so on. And the state has certain taxes, sales tax, excise duty on alcohol, electricity duty, and so on. And Godfrey Phillips has said, the Constitution bench, that there can be no overlapping of taxes. Now, after the advent of service tax and after the 46th Amendment, the 46th Amendment said that you can levy a sales tax on transfer of right to use and on restaurants and so on and so forth. So these were taken to be deemed sales and sales tax was levied. Now, these transactions also had an element of service tax on them, that there was an element of service. And you found that, let's say, for example, development of software. Software is goods. So there was sales tax on goods, and there's also service tax on goods. So the moment a show cause notice came, I would file a writ of prohibition saying that, look, this transaction is covered by sales tax, and you can't levy service tax. And I would always accompany it with a writ of declaration, where you have a writ to declare a particular provision as ultra-virus, Article 246 read with entry so and so, and also combine it with a writ of prohibition. So prohibition was very, very important, where there was overlapping of taxes, and I had to say that if it was coming in list 2, the union was prohibited from levying it. They couldn't make such an assessment. And if it was in service tax, it could not be subject to sales tax. If it's subject to union tax, it could not be subject to a sales tax. So typically, I used to combine it with a writ of declaration and a writ of prohibition. Incidentally, declaration also is not mentioned in the Constitution, but it's an important writ where the court has the power to declare a statute as ultra vires on grounds of legislative competence or Part 3 or and so on and so forth. Now, one observation I wanted to mention in the Tirupati case, the Supreme Court mentioned that it should be issued in the rarest of rare cases. I don't agree. Why rarest of rare cases? If there's no jurisdiction, that's it. Why should it be a rarest of rare case? So I don't think that this observation is correct, but I just thought I'll bring it to the notice. Let's go to the next slide, please. Yes. Now, writ will extend to administrative authorities. It's R versus London Council. In India also now it's settled law, so we don't have to waste time. One very important point from the point of view of lawyers is that the moment you file a writ, the first hurdle you face is alternate remedy. The first question they say, why don't you go back to the alternate remedy? Of course, as a tax lawyer, I believe that alternate remedy is only a theoretical remedy. There is no remedy at all, but then that is the way the law goes. You have to go up the channel, Assistant Commissioner, Commissioner Appeals, Tribunal, High Court, and Supreme Court. Now, there is a fascinating observation by Venkatrama Iyer. It's a minority view. It's para 144 of Bengal Immunity. And he says that if it's a writ of certiorari, alternate remedy is a very material factor. You can deny relief. But if it's a writ of prohibition and the petitioner can demonstrate lack of jurisdiction or usurpation of jurisdiction, then prohibition is a matter of right. It's not a discretion. And that's the observation of the Supreme Court. So the moment if I can show that a sales tax officer is trying to levy income tax on a very extreme case, then I have a right to get a prohibition, and an alternate remedy will not be a bar at all. So that's very, very important. Though I have had this case where sometimes judges will say that, look, you can still go and tell it to the authority. But this is the point I've been citing. It's a minority view, but I think it's the correct view. Of course, the majority doesn't touch upon this. He just goes into this issue. Now, as I said, certiorari after the order is passed, it's preventive. Now, just go to the, go down a bit before I get to the, I think I can't see its impact of Article 227 and Article 142. I don't have the time to get into the issue of 227. You see, a large part of our debate vis-a-vis English law is gone because now they said 226, 227, 136, all part of basic structure. You can't take it away. So the power can't be questioned. Judicial power is there. But even in 227, when the High Court has exercise powers of or the tribunals in it, it will equally have the right to issue writs of certiorari and mandamus. Now, Article 142 is a very, very unique article, and like many students of law, we sometimes wonder with amazement how this article, the Constitution has given certain specific powers. Now, my colleague brought to my notice Article 139. If you've got a Constitution barrack with you, please see Article 139 for a moment and read it with Article 32. Article 32 says that 32.2, which Chief Justice Sahi just read, says that you can issue these writs, habeas corpus, quo warranto, etc., for enforcement of fundamental rights. Now, if you see 139, Parliament may by law confer on the Supreme Court power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, for any purpose other than those mentioned in clause 32 of 32. Now, I have not been able to locate any such parliamentary law where they have said that beyond Part 3, you can use Article 32 to issue orders. So one point could be taken is when you're before the Supreme Court is confined to Part 3 and cannot go beyond, whereas the High Court is not confined by that constraints because it says writs or for any other purpose. To that extent, the power of the High Court is far, far wider than that of the Supreme Court. Now, coming to Article 142, The power of judicial review is through exercise of these writs, certiorari, mandamus, prohibition. I'll ignore for the time being quo warranto and habeas corpus because they're on different footings altogether. But under what basis do you pass orders under 142? The article says to do complete justice. One view is that this is like section 151 of the Constitution, that like 151 of the CPC, where you have some inherent powers to do justice, to give the finishing touches, so to speak, to iron out the creases, as Lord Denning puts it. But Article 142, in my humble opinion, has been used far beyond what it was initially contemplated. I'll just give two examples. Now, the Supreme Court levied diesel cess. They came with an idea that diesel is more polluting than petrol, and they levied a diesel cess. Now, where does the court get the power to levy a cess? 2%, 5%, and they said how the cess can be collected. So these are cases where it's not a certiorari, it's not a mandamus, it's a unique power being taken over by the Supreme Court, where they say that we can pass an order to any extent. If now the court feels now I appeared for the petrol cars, etc. in that matter. There's enough data to show that the pollution is not because of diesel; it can be equally because of petrol. The whole thing depends on the combustion of the engine. This is not the place to go into it, but I'm just saying this is a wide power. Other simple example is the Hindu Marriage Act says you can't give a mutual consent divorce before a particular period is over. But in that Anil Kumar Jain case, Supreme Court says we can waive it. Okay, fine. But then they go to say that this can't be waived by the high courts. Now, for the life of me, I don't know why. If there's some power to do justice in a case, it's not in a 226, but only under 32. Another mystery which I have not been able to sort out after so many years at the bar is why the prospective overruling is only done by the Supreme Court. If the High Court has the power to strike down a law, in my humble view, it has equally the power to say that, look, it will be prospective, it will not affect past transactions. But the Supreme Court says that prospective overruling is only for the Supreme Court. Now I'll just come to the short thing of Wade and CY. Very fascinating debate, and I would strongly recommend the youngsters and the younger lawyers, if you got the 4th edition of CY, start with para 16.200. He starts Anisminic with 16.200 and goes on. Now, what is this famous Anisminic case? Anisminic was a very simple case. And incidentally, when I talk of simple, pardon me for quoting from Kushal Das Advani. I think Chief Justice Sahi must be feeling this almost every day when he hears counsel. Fazal Ali, in his judgment, starts with these words, and I'll read it. This is, in my opinion, a simple case, but it has been greatly complicated by a citation of a mass of decisions by the parties in an attempt to extract from them some principle to support their respective contentions. I suppose this is the horror of every judge, that on a simple point, multiple authorities are cited. Anyway, coming back to Anisminic. See, Anisminic was a relatively simple case where, as you know, in 1956, Abdul Nasser closed the Suez Canal. The younger generation may not know it now. It was a big sensation in those days. The Suez Canal was closed and all the ships had to go right around the Cape of Good Hope. And I know my father was in the Merchant Navy, and he used to tell me that after 56, in fact, he was on the 3rd last ship which crossed the Suez Canal after Suez closed, and they had to go right around Africa to go to Germany and England and so on and so forth. It was a very, very big problem. Anyway, Suez Canal was closed. It paralyzed shipping traffic. And the Egyptian government nationalized assets also, including the assets of this Anisminic Limited. Now, what they did was, when the assets were nationalized, they told all their customers, don't buy anything from this Egyptian company. If you buy it, we will blacklist you, so to speak. So, out of fear or out of economic reasons, this Egyptian company said, all right, I'll pay you £500,000, but lift this ban. So, Anisminic and the Egyptian company Tido came to a settlement, and the matter was settled. So, Anisminic basically got what it wanted. Later on, there was a treaty between the United Arab Republic, which Egypt then became, and United Kingdom, and £27 million were given as compensation by Egypt to be distributed amongst the British people whose assets had been affected, whose business had been affected by this closure of the Suez Canal and sequestration of assets, as the word was used. Now, I would agree with the view of CRY. What the foreign compensation law said was that this compensation of 27 million would be distributed by a tribunal on certain parameters. And what is most important was Section 11 of that act said that the decision of the tribunal will be final and cannot be reviewed by any court. So under the amended Section 11 of the Tribunals and Inquiries Act 1958 and said the decision of this particular tribunal will be final and cannot be reviewed. Now, UK doesn't have a written constitution. If Parliament says you can't amend it, that's the end of the story. But yet, an outstanding bench of Lord Reed, Lord Wilberforce, and the third judge, they said no, by majority they said that the tribunal asked the wrong question and therefore they committed an error, and the whole thing was error within jurisdiction, error without jurisdiction. Unfortunately, time doesn't permit me to go into that. But apart from CRY, those of you who like administrative law, please read chapter 16 of Craig's administrative law. Craig has, in the 16th edition, has started with Anisminic, then he goes to Rakal, then he goes to Page, then he goes to Scottish Yorkshire Company, and keeps on tracing the development of things, and then goes on to Wednesbury and so on and so forth. So he has discussed how Anisminic was wrong, and has discussed the whole thing. Now, of course, in India, Anisminic is academic, and if you read the discussion between CRY and Wade, CRY first criticized Wade. Then in a series of lectures by Wade, which is called Public Law, lectures on public law, he countered what CRY said. CRY wrote a very strong response to that in rather very strong term, which is worth seeing, worth reading. And I think overall I would tend to agree with CRY's criticism. And he points out in that what Wade wrote in 72 was directly in contrast with 74. So CRY's basic point was, in a country with an unwritten constitution, if your jurisdiction of a tribunal is taken away, the courts cannot interfere on the grounds of error of jurisdiction, asking the wrong question, etc. He says, puts it very nicely, Craig puts it very nicely. If the test is, has the tribunal taken into account an irrelevant consideration? Has the tribunal asked the wrong question? So Craig puts it nicely. He says that means the court has come to the conclusion that the tribunal's conclusion is wrong. Its view is correct. And why is its view correct? Because tribunal asked the wrong question. In other words, court has got answer B, tribunal has got answer A. Court feels answer A is wrong, answer B is correct. So how do you justify answer B? You tell that you asked the wrong question, therefore you got the wrong answer. So it's a very nice discussion by Craig on this particular point. So this is as far as Wade and CRY is concerned. I'll just mention one important point, that on public purpose, see, Kushal Das Advani goes into public purpose, and there are so many cases which are not known, but which are worth considering. There is one important case, R versus Foreign Secretary, 1995, 1 Weekly Law Reports 386, 1995, 1 Weekly Law Reports 386. It's a remarkable judgment. You know, I had appeared before Justice Sadasivam and Justice Gogoi, challenging this free distribution of color TVs and freebies and so on. I said that under Article 282, you have to spend money only for public purpose. And what is public purpose is to be decided by the courts. There was a body of American case law which said, you can't use public funds to create private assets. I said, you can't give free TVs to people. You can have community television, community computers in school, that's fine. They're community assets, but you can't use public funds to create private assets. In that argument, I came across this particular judgment. It's a masterpiece, and you'll be shocked at the way, to the extent which English courts have gone. The Secretary of State of the United Kingdom decided to give 417 million pounds as a donation, as a grant, or as a economic aid for building a dam in Malaysia. It was to be handled by one unit in Malaysia, which is supposed to be involved in that dam construction. To cut a long story short, the court says, Section 1 of the Act says, the UK government can give funds for public purposes. They say what is public purpose is for me to decide as the court. They examine the law, they examine the facts, and they say that the NGO which filed the writ petition demonstrated that this 417 million claimed by Malaysia was far in excess of the cost of the dam. There were a lot of corruption issues and other issues. And the UK court struck down this grant of donation, this economic aid. So this is to the extent to which you are now gone in terms of judicial review, where a policy decision of one country to give aid to the other country is questioned before an English court, and it is struck down. So now this is the sum and substance of what I wanted to mention. I think I've covered most of my points. I'll only mention one thing, that as far as a writ of prohibition is concerned, as I mentioned, it is a writ which is not as popular or as commonly exercised as perhaps it should be. And when any lawyer gets a particular problem or a brief, if the order has not yet been passed and it is a potential danger, a threat of injury to his legal rights, then a writ of prohibition is the remedy which he can exercise, which he can which he can invoke. And very often, as I said, it can be invoked with the writ of declaration, prohibition plus this thing, or you can even simply stop a person from proceeding with a matter on which he has no jurisdiction at all. So I would thank the audience. I'll just wait for any question answers. I've summarized, I just focused on the writ of prohibition, and I'll now leave it to Arun to discuss the whole aspect of certiorari. I thought I'd speak on prohibition because that's a topic not normally spoken about. We focus only on certiorari and mandamus, but we ignore prohibition. Therefore, I thought I'll focus on this topic. Thank you very much. Thank you. All the best.